hope is that we can deliver the facts quickly, make them available so you know what you need to know and a way to get it, which is more important. Concentrate on questions that mediators have to ask. Apply the method, the process of mediation to some Social Security questions, and hopefully give you a kernel of wisdom to leave with. So our point of view here is that mediation itself is not about facts and knowledge. It's about a process, about the use of facts and knowledge in the process. And I know there are some non-mediator attorneys in the room, and I think that you will find that one of the most interesting inequities in equitable distribution is the Social Security piece. So I think if you leave with nothing else but that, you'll be looking for a good lawsuit down the line, because I've been waiting for years to get the right case to take this to the Supreme Court, because the judges don't get it, and I'll explain that later. All right, but before I start, I have to give you a quick Mullah Nasruddin story. Most stories, because they were told around a campfire long into the night, are long, so I had to find a short one and try to shorten it up. And so Mullah ran a school of enlightenment in the story. And the third person came up and said, well, how do you run the school? He said, well, I bring them in. I put them out in the sun for 10 hours a day. I make them chant all these verses. I don't feed them. I make sure that they don't have any other distractions. And he stopped. And the man said, well, how do you know when they're enlightened? He said, well, I send them home, and then I check the attendance at the next meeting, and whoever didn't show up, they're the enlightened ones. So that's probably apropos to our lecture tonight. So, okay. At this point, I wanted to say one more thing. If you want to become an enlightened mediator, there's some people in the room who would like to mediate. I suggest that you join with professional mediators, regional and national, and attend longer seminars, week-long seminars, and break bread with them. Attend the caravanserais, share their knowledge, because these are people that have been professional mediators 40 hours a week for the last 20 years or more. These are the people who can teach you how to mediate. Sit with them and try to get those kernels of knowledge that make you become a real mediator. Okay, having said that, why are mediators talking about Social Security? Okay, we're all generally aware of how Social Security works, and most of us hope to receive it someday, so we might as well learn a little bit more about it. We're doing it because of the fact that people, parties and mediators need help in understanding how Social Security works in mediation. How do you get the information to the table? So here we are. We're at our first session. You've done, in our case, the way we do it, first session, you get your homework. You come back in the second session, and at that point, you see what there is. Usually, they don't bring much back from Social Security, so you talk about it. So here's the questions. How much will you receive? When will you receive it? Do you know how to get the information? Do either of you have a pay situation that affects Social Security, such as a government job? We need that information. You two need that information to properly do this. How are you going to get it? Who's going to get it? Who can help you if you need help? Will you bring it to the next session? Etc. Okay. An aside for a practice tip. When we mediate, we always have a things to do page And we don't let the people figure out what they're going to do because they forget. They're clouded. They're in the middle of an emotional moment. So we write the to-do list at the end of the, as we go through the session. At the end of the session, you make a photocopy and you give it to each of them. That way they both leave with a clear statement of what they're expected to do before they come back. Okay, getting the information. Often they know what they've got. You know, a lot of smart people get divorced. And so ask them. If they're already in pay status, tell them to bring the statement of benefits. They can go online on ssa.gov. We've got the site there. Bring in current pay stubs to view, if they're still working, to view Social Security. They can go to their own HR benefits department at work, because especially if they have government jobs or jobs with so-called Social Security offsets, those people will give them information regarding that. Okay, so the information comes in, and then you are proceeding on the mediation. I'm on page 2, the myths surrounding Social Security benefits in a divorce. To make a long story short, while there are many wonderful judges, many of them are lazy. They take the easy way out. The easy way out is to say that because the federal government says that you cannot garnish Social Security, that therefore it's off the table. His Social Security is his, hers is hers. And there are cases around the country that say that. There also are some Rhode Island cases that sort of apply that thought. And if anyone is a litigator and wants to know the cases, I brought a couple printouts of those cases. But the point is, it's not supposed to be that way. Alimony is supposed to consider how much she's going to earn and he's going to earn, and the fact is that the rehabilitative alimony aspect that's in the statute has put a wall in front of judges, because they say if it doesn't fit into that rehabilitative thing, I'm not going to consider it in a contested situation. Well, that's totally unfair, because we all know that in most cases the man earns a lot more than the woman, the wife. Often retires with a Social Security benefit of $2,500, and the wife often gets a Social Security benefit of half that or less. But if they've been married and they get divorced, it'll be half that because of what we'll talk about later. But the bottom line is that's inequitable. In the assignment of property statute, it says the judge is supposed to look at the future income of the parties. It didn't say the future ability to receive income. That includes Social Security and such other factors as it would be to be equitable, the last catch-all. All of that says the judge is supposed to be fair about it, but it's hardly ever fair. And I've been in chambers 10 times with 10 different judges, and everyone says, we're not doing anything with the Social Security. It's off the table. Don't talk about it. And so you have to get the right case that you want to say, okay, let's have a trial, put it on the record, create a record, let's go to the Supreme Court and see if they agree with you. But at any rate, I have found that in the contested, it's hard to have a client who can afford to file an appeal, to go to trial, etc. In the mediation setting, it's a wonderful place to get more equity than you would get in the courtroom. And that's what we're talking about today. Okay. Practice tips. How do you do that? How do you start that process? Well, in the first session, what's one of the threshold questions you ask the people? What do you hope to accomplish in this mediation? And across the board, husband will say, well, I just want a fair result. Wife will say, I just want it to be fair. Okay, that's good. I hear you. I hear you both saying you'd like a fair result. Save those words. You might need them later. Okay? Then the next question is, when you're doing the mediation, how are you going to create the picture of what are the consequences of their proposals look like? Now, I use family law software, and I'll give you a little material from that tonight. But other people use a certified divorce financial counselor. Other people rely upon the engineer in the room who brings 35 spreadsheets to every session. Other people hire an accountant to help them. Often there's an accountant that has represented both parties for 10 years, and they both trust him. Okay, would you work with him to try to help do some projections, etc. In any event, you got to figure out, how do you take and show their future? Because I'm going to show you later, quickly, that the present looks fair, but look 15 years out and see what you get. That's why you need to do a little projecting. Okay. Now, later sessions, after the homework, after you've done the outside work product, so you have some projections, then you create and show a current budget report. I did a little playing with my family law software, and I just did one. Actually, I'm not sure. I did net worths, and I did, I did one budget report. And the budget report, this particular one, was one 2 years after the divorce. And this, she was still working. He was retired because of their age. She retired at age 67, but they got divorced at about age 64. Retirement age, well, it was full retirement age for Social Security purposes, which is about 67. And what happened is that she was still working until then, so she had a positive cash flow. Well, this is pretty good, and getting divorced, and I can afford it. But then after she stopped working and started collecting her Social Security, just as I said, I've got him down with a little cost of living riser at about $2,600 a month. She's at half that, $1,342, because the minimum she's going to get is half of his. She'll get her own or half of his, whichever's higher. Okay, and so bottom line is, at this point, starting at age 67, and he's retired too, he's positive $500 a month, she's negative nearly $1,000 a month. It's starting at age 67. And I put them in at a modest $45,000 each expenses. You know, not heavy expenses. But in any event, that doesn't necessarily show the whole picture. I'll show you one other thing. I'm sort of jumping ahead of myself, but this is okay. The division of marital property at the time of the divorce, it's all laid out there. Split the house, split the cash and investments, split the IRAs, and bottom line is they had about $1 million, and at the time of the divorce, equal, huh? $550,000 each, or whatever, $525,000 each, approximately. That's the equitable distribution. So then, from there, you show them the 15-year breakout, because if she's got even if she's got $550,000, if she's got a negative cash flow of $1,000 a month, their graphs after 15 years are going to look like that. Here's the husband. See, they're pretty close at the time of the divorce, even quite close. But because he's got a positive cash flow and twice as much Social Security, and by the way, I didn't do, the reason I did it the way I did it, there's no other extra income coming in other than the Social Security stream. So that these are primarily as a result of difference in Social Security. His is straight line but going up. Well, I'm sorry, it's going up slowly, but it's going up. Hers is going down. Bottom line is, after 15 years, he's at $419,000, and she's at $241,000. Now let's look at 20 years. Well, that tailed off, didn't it? That's hers. He's at 379, I'm sorry, he's at $687,000, and she's at 47. And why is that? Well, he was getting about $15,000 a year more, times 20 years. You can do the math. That's, what, $300,000 there alone. However, to make up the shortfall every year, first of all, she had to go into her cash. That was gone after about 10 years. After that, she had to go into her investment assets. Well, that started in 2030. That started going down. And then finally she had to go into her IRAs. So that she was living off of her investments, and the bottom line is they were going down to the last year on this chart. She is 79 and she's down to 241. That's that particular one. But 10 years later, I'm sorry, 5 years later, that's 50 and 20. 5 years later, she went from 241 to 47. So that's what happens. That's the inequity of Social Security. And so what do you do with that in the mediation? You show them that chart, and you don't say, look at this, it's crazy that you can't, it's their mediation, it's not your mediation. You're just helping them talk about it all. So what you do is show it to them and say, what do you think? Well, what do you think they think? He doesn't have a problem with it. She's going crazy. So you say, and so then what does the mediator say or do? See, the two of you are having a difficult time with this. What I hear you saying, the other guy, is, I talked to my lawyer. He said Social Security's off the table. What's mine is mine, what's hers is hers. That's it. It's not subject to equitable distribution. So that's what I want, and that's what's fair. And then he points to the equitable distribution is 50-50 at the time of the divorce. Okay. What does she say? We've been married for 25 years. I raised 3 kids. I stopped, my work is, my work knowledge is stale. I'll never make anywhere near you will for the rest of your life. You can work for another 3 years and then no. So, and I put that in here. And you're going to make $2,500 a month, more or less, and I'm going to make $1,250 for the rest of our lives? That's nuts. That's what she's going to say. And an interesting aside is she saying that because she wants the whole thing to be fair? My experience has been she's saying that because she's afraid that the assets she has won't last her long enough, and she's going to be a bag lady. And I've had a lot of clients that looking at $1 million in assets, and it takes me, a client as an attorney, and it takes me a long time to explain to them they're going to be okay. Because I ran the numbers, and they are going to be okay. But they don't think they're going to be okay, and especially when you show them a chart like that, at 85,000, at year 85 years old, I'm going to have $40,000 left. That's it. So, so what do you do as a mediator at that point? The first thing you do, it's not your problem as a mediator. It's their problem. So one thing we often say is, geez, you guys have a problem. Put it back on the lap. Right? Then you say, what are you going to do about it? And then you sit back. It's quiet there, isn't it? It's quiet for a while. The answer is, then you have to say, well, pointing to her, you told us that you feel very badly about this, and it doesn't feel fair to you. And then you say to him, how do you feel about what she's saying? And you'll get something out of him. Say, well, we understand that, and I will give black letter law. I will not give legal advice. I will say things such as, there are people who think that the conventional wisdom about Social Security and equity not being part of an alimony equation or not being part of equitable distribution is wrong and unfair. But forget the law. That's why you're here. You're here to avoid that view of things. You both said the first time you were here that you wanted the result to be fair. Does this look fair? Show it to him. All right. Are you willing to discuss some other things that might help with this, that might ease that inequality? And most of the time, you will have both of them say, okay, let's talk about it. So what things can you throw into the fire there without telling them what they should do? One thing would be, gee, you mentioned that you still have 2 children that haven't finished graduate school and you'd like to help them. Do you think you can help them in this picture? No. You're going to have $600,000 worth of assets, it says here. Do you think you'd be interested in do you want your kids to get their education? Yeah. Would you be willing to help there? Yeah. Would you understand that she can't help there? Yeah. And then you can go into an agreement that no one could ever get in the courtroom, because in a courtroom you can't get a judge to order that education expenses for children will be paid. But you can put it in the agreement. All right, that's an example. Another example, just off the top of my head, things you can talk about is that if you took, for example, $200,000 worth of his 401k over an extra and gave that to her, it wouldn't affect his bottom line that much, because after these years he wouldn't have 600,000, he'd have 400,000, because he lost some of his income. If you moved $200,000 of 401k over to her, she's almost 70 and a half years old. Once she's 70 and a half years old, she has to take her required minimum distributions from 401ks. 100,000 roughly equates to, Rick could probably give a better answer, but roughly equates to about
$5,000 in the first year.
50,000. What's that?
About $4,000 in the first year.
That's what I was going to say. About $350 a month. All right. So if you did that times 200, that's $700 a month. If you increased her picture by $700 a month through this entire period, she'd be fine when she was 85, and he'd still be fine. Now, I don't suggest that. I suggest that he has the option of moving assets, and he doesn't want to move his cash. No, he doesn't want to move his investment accounts. No. But how about if you move some of that stuff? Are you interested in talking about that? And maybe he will. If you move $200,000 worth, you're going to put, like you say, about $8,000 a year in her pocket that she didn't have before. So that's the kind of a thing you talk about in the mediation. You look to the goals and interests of the party. What's her goal? Educating the kids in some cases. Not being a bag lady, and try to tie it into what his goals are also. I repeat here, your job is not to judge what is equitable. It's not your job as a mediator to achieve equality of result at the time of the divorce and forever. It's not the job of the court. They tell you in the courtroom to achieve equality. That's not how the divorce law works. I have to make a quick aside that I had better results fighting for women 30 years ago before the alimony laws changed, because you could go to a judge and say, this is ridiculous, she's got to have alimony, and you could get it. But because of the way the alimony law was written in Rhode Island, okay, 3 years and you're toast. That's it, or maybe 5, something, whatever. But your job is to ensure a full discussion of the consequences of their proposals to each other. Mediation can produce a better result than the courtroom can, and we've done it many times. One other thing that sometimes works is they can agree to pay alimony. And sometimes you can transfer, if husband is still, let's say they're still working and husband earns $200,000 a year and she earns $50,000 a year, you can have him pay alimony to her so that she can build up a bit of a bank, and he's going to get a write-off of about 50 cents on the dollar for what he's giving her, and she's going to only have to pay 15 cents on the dollar for what she's receiving. So the difference, 35%, is money transferred to her gratis from Uncle Sam because of the disparity of their tax brackets. All right. That basically ends my, okay, this is the mediation thing. Now I want to get back into some of the things that people should be aware of in terms of, I'm on page 4 now, about Social Security. First of all, this is not Social Security per se, but it's connected. SSDI, that's a situation where there's a disabled person and they contributed to Social Security during their working life, therefore it's not income-based or asset-based. So an SSDI person, their benefits will not be affected whether or not they get alimony or whether or not they get child support or whether or not they get more assets, whatever. But SSI, that's paid as part of Medicaid or Medicare. It's cash assistance to people with disabilities who have very limited incomes and resources. And it provides Medicaid. So if you're on SSI, you're receiving all your medical stuff is taken care of for free. That's big, right? So you have to be careful what they get. When a client or a child of the parties is on SSI, you've got to be careful. Small increases in income or increases in assets can stop the SSI. I just could put an example in there. An SSI beneficiary is a minor. His or her parent is ordered to pay child support. The SSI benefits can be lost. Complicated rules. Have them get an expert to talk about it or figure it out, because it's not your job to figure out whether or not their child is qualified or going to lose SSI qualification. Interestingly, there is a technique that's been used that in that case you can create a special needs trust. Child support can be paid into a special needs trust, just like a automobile accident settlement can be put into a special needs trust. So you don't lose governmental benefits. The assets in the special needs trust can be used for things other than what are provided for by the government. Okay, 10-year rule. This is pretty simple, really. If you're married for 10 years, you get certain benefits relating to Social Security. If you're not married for 10 years, you don't. So therefore, if you're an attorney and someone's sitting inside and they say, I can't stand this guy anymore, it's a 9-year marriage, I want out and I want out now. What are you going to say? Don't be stupid. Just allow me to drag my feet a little bit. And we'll put the final judgment through 10 years and a day from now. And so it's important. I've read books that said if you don't do that, then you have committed malpractice. So just worth considering. The other thing is, though, is that most of the time we're thinking about Social Security, we're thinking about people that are up in their 60s or late 50s and stuff like that. But if they ask the question, they might be 40 years old or 35 years old, and you still might want to talk about that 10-year rule. You know, should we keep you married for 10 years? We do the same thing in military quadro work, military benefits work, because if there's a military survivor benefit, you can get it if there's less than 10 years, but you have to collect it from the military member who may be long gone. If you're married for 10 years and then you get your survivor benefit, then the money that comes to you comes directly from DFAS. Well, just leave it at that. You want your 10 years in a military divorce because you want your money from the government, not from him. All right, that's just an aside. Okay, how are we doing? What are we doing? All right. Talking about the spouses again. A widow or widower at full retirement age, 67 or so, it's changing slightly, receives 100% of the worker's basic benefit amount. So the best thing that could happen to the lady in my scenario here is that if he dies, then she would get that $2,500 because the widow, because that's the widow's benefit, but the Joni Carson result, the next one, is the same thing holds true for a spouse if you were married for 10 years. So this is the funny one. Joni Carson was married 4 different times to 4 different women. None of them remarried. All 4 marriages were for 10 years.
Oh.
When he, assuming he had full Social Security benefits of, let's say, $2,000, or just say it's easy to multiply, $2,000 a month. After he died, 2,000, 2,000, 2,000, 2,000. That's the Joni Carson result. Okay.
Excuse me.
The spousal benefit for a divorced spouse. Well, I spilled the beans, but there's other stuff, and Rich will discuss that. All right. There are two other things here that really I think are a bit too complicated to go into, but I'll tell you I have given you 2 handouts. One is windfall elimination provision. The other is government pension offset. I'll just tell you what it's about, and then you can read to your heart's content. If you are married to a person who is well, first of all, if you're a government employee, often you don't pay into Social Security, you pay into the government pension. Interestingly enough, that pension is fully divisible. So in that particular case, the wife of a government employee, he's got his pension. They were married the entire time he was working there. You divide it down the middle, she gets her piece, he gets his. Why wouldn't it be the same for Social Security? They were married for the entire time, in his entire working life you were married, but for some reason in Social Security, you get what you get. It's a different, there's no sense to it. However, the fact is, though, that because you divide up that pension, yes, but because there's no Social Security, then the wife is not going to get any Social Security, except usually they often get some Social Security and the government pension, and therefore the wife can get some, but there's a reduction of spouses' benefits for government employees. Again, if you're going to be doing this stuff and figuring out what their future's going to be like, you have to know this. So you have to make sure. And how do you find out the offset? They know. They're sitting in front of you. They all know they've got offsets. So that's that. The other one is the windfall elimination provision. That's a situation where a person has Social Security and he has another pension, and because they're getting 2, the government says, well, the government's going to take care of you, but we're not going to take care of you twice. It's a windfall. So therefore, there's some provisions that eliminate part of that pension. Sort of like the other offset thing. Again, we'd be here all night on just those 2 pages. But if you need to know if they're working for the government or have worked for the government, these 2 things may apply, and that is that. And now I will turn the floor over to Rich.
Turn the floor over. And we're going to have time for questions after. So I realize sitting here that now as somebody who was divorced and went through mediation and became a fan of mediation, that's why one reason I joined, now I have to, in good conscience, being a Zen mensch, I have to go back to, now go to Jeremy and figure out my Social Security earnings so I can make it equitable with my ex. Because nobody, all excellent mediators and attorneys, nobody mentioned it. And I didn't think about it. And the point you made about the pension being divisible, it's like a no-brainer. So,
Right.
so nobody brings it up. Just like I've had, this isn't Social Security, but people with government pensions who take a higher benefit, assuming they're both going to live, and then their spouse, if they die, their spouse doesn't get anything, rather than opting for a lower benefit and assuring that their spouse will continue to get something, which you have the option for in at least in state pensions and probably federal pensions also. I had a client who did not have a great marriage, but she didn't work, and she didn't, a lot of people don't know this, especially, again, maybe older women who didn't work as much. She just had no idea, that's the way it was set up until he died. And then her financial advisor told her. So I do have these little, if I ask questions, well, you'll see. I did bring some props, and some of them are up there. So, just so you know, Zen Mensch Accountant was not actually the name that I came up with, although it does reflect my background. I lived for 7 years at the Providence Zen Center, which is a meditation center in Cumberland, before I grew up and moved out and became an accountant. And I'm still involved there. It actually started in Providence, where Tokyo Restaurant is now. And before that, for people who go back further than me here, the Golden Sheep. And then I'm Jewish, so I have a Jewish background also, so somebody online recommended me, and she came up with that name, and being who I am, I figured, well, I'm just gonna, Zen or not, I'm just gonna promote it, so, or use it promotionally. So my little Zen story is the Zen master who was the main teacher or the lineage holder at the Providence Zen Center was Korean. He died about 8 years ago. Very charismatic, broken English, great story. He came from Korea, he was a famous teacher, no English, fixed washing machines for a while, then built up a network of Zen centers. There are a lot of these people floating around. So he, a lot of Korean people have this characteristic of being a little bit outrageous and kind of no holds barred, and he was definitely that way, kind of like crazy wisdom. So in Zen practice you have interviews, private interviews with the teacher. So in the mid-'80s, when I first met him, I went in, he asked a koan, which is like a Zen riddle. You don't know what the hell you're doing, so you say anything. So they have these Zen sticks. So he asked me something like, what's the sound of one hand clapping, or something. And I said something, and then he takes this stick and he goes, "You Jewish, too much thinking." A lot of wisdom there. Okay, so what I'm going to do is I'm going to go through Some basic stuff about Social Security, a lot of which is even a little bit new to me, and then focus probably more than anything on some of these changes that I would be surprised if more than a third of people here knew about, because it just has not been talked about, but there are some important changes. And just as background, so I'm divorced, I'm 62, I'm a CPA, I have kids. Some of this stuff I'm going to tell you, I did not know. Just like I didn't know about, take Social Security into account. There's just a lot of things to consider in life and in these situations. So some of the stuff I've learned about does not exist anymore, except for a little window of opportunity that we'll talk about. So, first question is, how much is Social Security tax? Anybody know?
You want an answer?
I'd like an answer, sure, so I can use my button.
Anybody else know?
15%?
But that's good. 15% is payroll tax because you're including Medicare. So Social Security tax, Social Security and Medicare this is especially important for people who are self-employed. So this is a little bit about taxes, but it kind of plays in a little bit with some financial planning. Social Security and Medicare are two-tiered systems. Employee pays half, employer pays half. So when I'm an employee, I pay my 6.2% of Social Security of my wages, 1.45% of Medicare comes out of my paycheck. I don't see it. The employer pays the same amount. I don't see it. Then I go off, or I'm fired, and I become a consultant. How much do I pay?
Both sides.
15%. Self and other, as they say. Self and no self at the gas station. I'm the employee and I'm the employer. I pay 15%. Now, it's on my net earnings, so it's income minus expenses, but it's an absolute killer, and I talk about that more than anything when I talk to people who freelance. So especially, say, if somebody's divorced or they're thinking about some change in career, it's just something to be aware of. If you're repositioning yourself and you're going to become, especially, say, a consultant, or a self-employed attorney, therapist, where you don't have a lot of expenses, you don't have a lot to write off, you're going to get hit with that 15%, again, on your net. There are some strategies to incorporate to limit it a little bit, but the one thing I always get a kick out of during political campaigns is, might be a little bit different this year, but people always talk about cutting the income tax. How often do you hear them talk about cutting the payroll tax? Not very often. Medicare has no limit. So you make any amount of income, your wages are subject to that total 2.9%. Social Security right now is capped at about $120,000. So you make over that, you don't pay Social Security tax. That might change in the future. Certain candidates might make a thing about that, or maybe not, but it's just something to be aware of. So some of the things I'll just go through briefly, and some of this may be self-evident. Social Security obviously means more to low-income people, again, partially because of that cap. So if you're the spouse, you're making $1,000 a month, based on those earnings, that may represent up to half of your income in retirement, or even while you're working, even more so. In retirement, it's probably going to be 90%. So obviously, when you're thinking about Jeremy's scenario, there's not only the inequity, but there's, as you get older, somebody is going to have lower earnings, and she's going to have lower income and lower cash flow from other places, so they're even more dependent on the Social Security. So another thing, of course, when being a CPA, and I see that, of course, we all want to limit our taxes, and you know, painters driving around in Mercedes, but they actually lost 15,000. Just exaggerating just a little bit, but they. These are not usually people who come to me because I wouldn't sign the return, but you know, people who are living comfortably or they're getting by, but they just never seem to make a profit, just never. So that's great in terms of filing your taxes. It's not so great if you go and try to buy a house, and it's also not so great, especially if that's been your whole life, for building up your Social Security earnings. You have to have, I think,
40
40 quarters of Social Security earnings in order
to be eligible for Medicaid and for Social Security.
Right, 40 quarters, okay.
40 quarters, 10 years.
Right. But they use the highest 35 years of earnings to figure out your benefit. So if you had, you know, you might have some very low years there, that's going to come into play. So again, you know, 1 bad year, 2 bad year, you know, 1 year when you're being aggressive on your taxes, that's okay. If you do it all the time, you know, you got to be a little bit careful, because people aren't thinking about it when they're 30 and 35, but that's going to start to negatively impact your Social Security down the road. Okay, another important element is early retirement is at age 62 currently. You can start to take Social Security benefits. You get it's 25% reduction. A lot of people take it. I've read like up to a third of people take it because they have to take it for cash flow. The other part of that is essentially for every $2 of earnings, they lose $1 of Social Security benefits during that time. And the way it can be done, it can even be done, I'm not even sure how the Social Security tracks it, but it is done, and it can be taken in a number of ways, including, say, the first 6 months of the year, you don't get any Social Security, and the next 6 months you get full Social Security. So that's the bad side. The flip side is, by some complex formula that I do not understand, maybe you do, when you do reach full retirement age, Social Security will recalculate your benefit, and basically you recoup those earnings. I'm not sure over what amount of time or if it's exactly 100%, but there is some return on that. Plus, if we're talking about the 35 years, if you're still earning a good wage and you haven't fulfilled those 35 years and your earnings are still pretty strong, you're going to raise your monthly benefit. So people might have to do it, but it's not, you know, when I was first looking, I thought, you know, don't do that. You know, just defer your Social Security because you're going to end up losing it anyway. But if you have to do it, which is still probably not the best strategy, but if you have to do it, there is some recompense down the road in 4 or 5 years. So that's early retirement. And also this is important too, is that reduction in benefits only happens if you're making more than, this is adjusted for inflation, but 2016, $15,720 from W-2, which is employment, and freelancing, consulting, self-employment, 1099, all that good stuff. Okay. My favorite cartoon is on page 2. Ruth said, find some good koan. And I looked, koans and Social Security. I couldn't find anything, but I did find this one. So full retirement is 66 if you're born between 1943 and 1954. So between age 66 and 70, these are really like the golden years. This is what everybody wants to do, if you can do it. If you delay your filing from, say, age 66, now it's going to creep up to 67, until age 70, 8%, your benefits accrue or increase 8% per year. That's huge. That can be 32%. So only 10 to 15% of people are able to do that, but that's optimal if you can do that. So it's something to keep in mind as you're helping your clients or talking to a financial planner, if they can do that. Let me do it for a couple of years.
One thing there,
Yeah.
that an important consideration when you're talking to anybody as an advisor about Social Security benefits is to don't forget to ask them, how's your health? Because nobody wants to defer benefits and wait for their money
Right.
if they're going to die soon. So, don't forget to ask that question.
Good point. Okay, in terms of taxability, so this is another thing that happens if you're working and taking Social Security. So then you think about the things that are going to happen if you're taking early retirement and working, is you're going to have, your benefits are going to be reduced ongoing. You're going to have reduction in benefits, at least temporarily. And the third thing is your benefits might be taxed. So on the federal level, the essentials of the formula are, if Social Security is your entire income, it's not going to be taxed. So this only applies if you're working and making something. So the something, bare bones, is your non-Social Security income, let's say your wages, plus 1/2 of your Social Security income. So I make $15,000, I'm single, I make $15,000 a year in earnings and $12,000 a year in Social Security. Half of that is $6,000, so that's 21, right? I don't have a whiteboard. Okay, so if you're single, the threshold is 25,000, so none of your Social Security benefits are taxed. Now let's say I'm at 20,000 of wages, 12,000 of Social Security divided by 2, that's 6,000, 26,000. So $1,000 of my benefits, $1,000 of my Social Security benefits are going to be subject to tax. So the other part of that, so that's kind of a complicated formula. That obviously, if you're making $40,000 a year, $50,000 a year, or I see this with married couples all the time, and they're making $100,000 a year and taking benefits, then they're way over that threshold, which is a little higher for married people. So their Social Security benefits are going to be taxed. The other piece of that is it's not all of your benefits, but it's up to 85% of your benefits that will be taxed. So that's a little bit confusing, but essentially it's something sometimes you can't avoid, but it's something to be aware of. In Rhode Island, effective this year, which means we're filing next year, there's a slight reduction in Social Security benefits subject to tax under a certain threshold. It's about $80,000 if you're single. It's not a complete reduction, it's a partial reduction based on, again, that formula.
So Rick, I have a question.
Yeah.
So the income that is counted to determine whether your Social Security benefits are taxable is actively earned income.
I believe so.
Salary, wages, self-employment, not your investment or other.
I'm not 100% sure, that's why I deferred. I was reading about that this morning, I'm not sure.
Okay.
And is it gross income or net?
Well, it's net from self-employment.
Okay, but
It's always net from
otherwise,
self-employment, but
it would be
Bruce
gross.
right?
Yeah.
Had a good question, and I'm not sure. I think it might be all your earnings,
I think so
but
too.
not 100% sure. Okay, so here's the main thing, and here's where you really have to pay attention, and it's too bad that Kevin Wardley isn't here, but he's a financial advisor who deals with a lot of divorced people. So what Yes. What Congress did. We have somebody in our office who, she's the managing partner, and she's wonderful, and she's a complete doormat. So she tries to make herself off limits, and people knock on the door. Okay, I found that. So one of the secretaries got her a...
No!
got her one of those. So
Like to get one of
just
those.
after Halloween, in November, as part of one of these big budget reconciliation bills, snuck in there, not even real, and not a little bit surprising to me, it wasn't even a point of contention. It actually was in Obama's budget, and the Republicans went along with it. Republicans, who knows who fought for it more, but with very little opposition, very little debate. AARP was okay with it. Who's ever heard of file and suspend before tonight? Okay.
I have to stop for a second, because this is the point when he and I were talking about it,
Right.
and we said, okay, now we're going to have to tell the attendees that something they never knew existed before
Does not exist.
doesn't exist anymore.
Right. It's a good sense story. Right. Did it exist? Did it ever really exist or not? So, but it also ties into this 10-year rule. So file and so yes. So
What
I guess- yeah.
was file and suspend?
right. And the background to this is, well, I'll get to the background, but file and suspend means okay. And it's primarily for when you're married. It has to do with spousal benefits. So we're married. I say Max and Molly, we're married. I'm not going to simplify it because it can get really complicated. We're 66. We're at full retirement age. I want to retire and watch football games and visit the grandkids. She wants to keep working. So what you could do under file and suspend is I file for my benefits and then I immediately suspend them. So remember that 8% we're talking about, the delayed credits? So I've suspended, I'm not taking my benefits, accrues 8% per year until I turn 70. Now Molly, she wants, no, I'm sorry, so I want to keep working. She wants to watch football games. I want to keep working, so I file and suspend. She wants to retire. So she can file for a spousal benefit on my earnings, because I'm not taking them. Not now. So because they're on my earnings, her benefits also continue to accrue for at 8% a year till age 70. Age 70, unless she really didn't work very much at all, probably her spousal benefit, which starts at 50% of my full retirement age benefits, not the top one at age 70, hers continue to grow 8%. So when we're both 70, mine are 30% higher, hers are 30% higher, so now she can switch to her benefits because it's much higher than they were before and higher than the 50%. Does that make some sense?
Yes.
Without a whiteboard? That's gone. Almost all gone. Almost all
I have
gone.
one more thing to that.
Yeah.
But not only that, that a former spouse who was married to
Right.
you for 10 years
Right.
could also be in the same situation.
Right.
So you could have two, a spouse and a former spouse, if you had 10 years for both
Right.
of them,
Right.
doing the same thing.
Right.
So can I?
So yeah, but so let me just
Yeah, right.
finish this thought. So where it really applies to this audience is, so if you're, as Jeremy was saying, you were married for 10 years, you did not remarry, although I believe if you're over age 60, you can remarry. You were divorced for 2 years, then now you can still do this. You can still go and claim on Johnny Carson's benefits and get half. But your benefits are not going to continue to grow. So I think it's a much smaller number of people that are going to be helped by that, because half your benefits permanently, in most cases, are not going to be, no, half of his benefits permanently are not going to be higher than 100% of yours. So it still applies. You can still, it's not file and suspend, you can still do that spousal benefit on your ex, but it's a value to a much fewer amount of people. Now is where, okay, if you have people in a certain age situation, which I can't tell you how many experts I've consulted with, and I found a couple, including Kevin, who understood this because there's been very little guidance because it's so new. There is a grandfather clause. You have to file. Now this is for the traditional file and suspend. I actually have to look at my notes on the last page. So, okay. If you were 65 and a half at October 29, 2015, and you filed by April 29, 2016, you can do the file and suspend. You really need to talk to a financial advisor. They may even need to go to Social Security. Social Security, in typical fashion, because of budget cuts and whatever, until a week ago, the people staffing the offices had not even received any guidance about this. So it could be flooded, they could be flooded with stuff as you get closer to April 29th. I've also heard that the fact that the divorcee benefit does not grow, that might be fixed. They're calling it an unintended consequence. Who knows if that will happen? As of now, it does not exist. Again, unless you're in that grandfather clause. That's the basic. That's the basic stuff of that. So, but yeah.
Yeah, all right. Well, he's definitely got an easy question. He won't process it.
So if you have a couple, Johnny Carson, he's married 4 times, he has 4 wives, they've all been married over 10 years, they get divorced, and Johnny made much more than they did, so they collect half of his benefit.
They have that option. They can file and collect half of his benefit. Yes.
So they take half his benefit. When Johnny,
as long as he, now the other thing, he has to have started. This is new also. He has to have filed for his benefits.
okay, he's filed for his benefits, then he croaks while he's getting benefits. Do they get the step up to the full amount?
Yes.
Because otherwise, I'm just thinking of the scenario, how else would it kick in?
No. When he dies, they get whatever his full benefit was. The full benefit, not half the benefit.
Full benefit.
So they'll get
That's
that
why
once he croaks.
just use the number 2,000. He was getting 2,000 as his full benefit. After his death, each of the 4 would get 2,000.
Okay.
So now you know why Social Security is going bankrupt.
Yeah.
It's not going
There's a little
bankrupt.
incentive for the wife to, if I was Johnny, I would never have had dinner at my ex-wife's houses. But that step up.
Well, it doesn't affect him. I mean, that's the remarkable thing.
but if he died,
It affects them. Right. Oh, I got it. Yeah, I understand. I understand. Right. I understand. Right.
So, a factor you have to consider, or I would want to consider determining when to start taking benefits or and advising someone else on that, is how long am I going to live? How long will they live? So, do you guess? Or do you have a source?
Do I guess?
What do you do? Exactly.
Well, I think that's what Jeremy was talking about, is I guess try to talk to them about their health.
Yeah, I think the Bureau
Which
of
is-
Labor Statistics will have estimated life.
Oh, yeah,
Or your financial advisor, right.
Well, there are calculators. You can go on the Social Security website and do calculations. And there's calculations all over the internet.
It's
You just,
based on your age. Right? What age are you now? How long
Right,
have
but
you
that
been?
age is for the average 78-year-old or 65-year-old, and if you have somebody who's been told, you have a serious congestive heart problem,
Right.
take it as soon as you can get it.
Go see the doctor. All right, thank you.
I'll pass
I
it
guess,
around.
and I don't mean to belabor this point, but
Believes everything else.
Belabor. What else is new?
only when I'm getting paid.
Pass it around.
So, I forget the name of this rule, because I started to understand it, and you went off into Zen land, and I got confused. So, let's just scenario, 62-year-old husband, 56-year-old wife. They get divorced right now. She can start receiving a portion of his Social Security benefit.
Not until
No.
she's
Well, first of all,
good.
there's
when
the
she's
10-year
59
rule.
Well, they're married for forever, for
Okay.
10 years. So 59 and a half she can receive, or how old does she have to be?
No, she has to be at least early retirement age.
Which is 62.
And he has
Yes.
to have filed.
He has to have, that's another change. It used to be, before I didn't know about it, it used to be
He didn't have.
as long as he was 66. Now he has to actually have filed. So you have to look at both of them.
The other thing is if she takes it before her full retirement age, she won't get 50% of it. She'll get a lesser number because they will then sort of re-amortize the fact that she's getting it earlier by the fact that she didn't wait until she was 66.
And how is that different?
But next,
How is that different for the widow or the widower?
well, the widow can take once the widow has, I'm trying to think, what
Because
age
this-
does the widow have to be before she can take? I think she can take it 62, but she wouldn't, if he was already in
60
full
or
retirement
62.
age and receiving, but she decided to take it 62.
Would it be
No,
reduced?
actually, wait a minute. No, that's different. The widow
So-
can take as soon as he dies.
No, I think the survivor has to be a certain age, and I'm confused under your widow's rule because it says at full retirement age, the widow or widower gets 100% of the basic benefit amount, and of course that you say they have to be married at least 9 months, but then it says must be 60 years old. 60 is not full retirement age.
Right.
No,
Right,
no,
it's a special rule for a widow.
Okay, it was 60. What number is that?
Well, it says must be 60.
I think it is 60.
And is that regardless of the income of the widow or widower?
I believe so.
No, it's totally dependent upon the spouse who died presumably had higher Social Security. And so then he dies. If she's been married for this amount of time and she's got
Yes.
filled those requirements.
Yes.
Once she's 60, she can get his full benefit.
His full benefit?
Yeah.
Even if she's making in excess of that 15,000?
Yes, the 15,000 is if you're
Doesn't
earning
apply to
regular
the-
income, and that matched against your own Social Security income. So,
Yeah, and nothing in these rules, nothing that affected widows were in this, or widowers were in these rules.
Is in the
So whatever
notes.
existed before does exist for widows
For
as well.
widows,
Yeah,
okay.
Nothing was affected.
I think the collective Social Security.
you can carry on, because I think I actually have a
handout?
blurb on that.
Yeah, I'd like to know a little bit more
So I
about
handed out
that.
some stuff, and there's more. There's actually
Yes.
even more up front. And one of my hobbies is producing self-important business cards and magnets for myself. They haven't killed anybody yet.
I'll just respond to her question. This is not the whole thing. This is from the Social Security website, but a widow or a widower at full retirement age receives 100% of the workers' benefit amount. A widow or widower under full retirement age receives about 71 to 99% of the workers' benefit amount. And then there's another thing here about if she has a child younger than age 16. So the point is that if you're a widow or a widower and you start taking it before your full retirement age, they're going to reduce it down from the full amount down to 71% to 99%, depending upon when you start taking it.
And that's fine, it's just that it has there's no qualification for however much that widow or widower is making, however much their income is.
That one I would be hard pressed to say with certainty, because I think they can earn whatever they want. It's your own Social Security that get matched against your income. I don't think it's your
the deceased spouse's. Okay,
Social
all
Security.
right.
That would be my guess.
Okay,
Don't
all
quote me.
right. We'll have to call the 800 number and wait for 40 minutes.
Have you ever worked with Social Security?
Well, I've called a number of times,
I'll
and
tell you what, the Social Security offices that I've been involved with are the best governmental offices that I know of. You go there and you take your driver's license. Don't even call. Just go there. Normally, you're sitting in front of a worker within 10 minutes.
Really?
Yeah,
They're
really.
so nice.
Where's that?
They're super nice.
Yeah, and they're terrific. So
Where is that office?
Where is that office is right.
Oh, Newport.
no, but I've heard it. I heard the one in Warwick or Cranston, wherever it is.
Not in the city.
But Warwick or Cranston is one. But Newport, you can get sitting in front of a person within 10 minutes, and they put you up on the screen, and they're
Probably
great.
faster to drive to Newport than wait somewhere else and go to
So
it.
we
Okay,
still have more time. So
thank you.
let's talk about any more Social Security questions, or I'm interested in and those who are mediators or would like to be mediators. What was your reaction to how do you handle that difficult question? Because it's not the only inequity you find, but how do you deal with inequities when you're sitting at the mediation table? This is just one of them. The other one, the other major one, even bigger than this, is husband earns $150,000 or $200,000 a year, wife makes $40,000 a year. You get divorced, you divide the assets equally. You may get some rehabilitative alimony for some short period of time, but if you're already making $40,000, you're rehabilitated. You have a job. You take and run those numbers for 15 years and see what he's going to be worth in 15 years and what she's going to be worth. Totally inequitable. What do you do at the mediation table? It's not your job to equalize it, but it is your job to have the conversation. To how do you feel? And you won't have the conversation unless you show them. It's okay to show them the consequences of their agreement. Okay, that's what you're talking about doing. This is your offer. This is what your offer looks like, and this is what it looks like in 15 years. That's when. Now, have you committed an ethical problem as a mediator because you've highlighted the fact that it's a terrible result? I don't think so. I'm not going to sit there and say, "How could you do that to her? What's the matter with you?" You don't go anywhere near that. You're not a judge. You're a guide, and part of the guide is to show them the landscape. And if the landscape's unfair, how do you feel about that? I think it's awful. She thinks it's awful. What do you think? Because it's all on them. You guys have a problem. I don't have a problem. If you keep fighting, you keep coming back, and I make more money. All right. Any other thoughts about mediation? About mediating Social Security? I really am serious about the fact that, again, judges work hard. I'm not, but sometimes they take the easy way out because, especially in the family court, I find that this myth that Social Security, it is what it is, and you don't get any more, and she doesn't get a piece of his, and he doesn't get a piece of hers. That's true on its face, except for the fact that the equitable distribution factors and the alimony factors all are supposed to take into account the equitable nature of the process. I can't believe that the legislature has let that sit for 20 years. No, I can't believe it because the head of the Senate was a family court lawyer who knows darn well what that statute's doing. That's why I can't believe it.
But you know, the courts are required to consider equitable distribution before they consider alimony. So if someone's getting a bigger piece of the pie in terms of the split of the assets...
They rarely do.
Well-
The judges that I've had in Newport County for the last 15 years have been loath to do anything other than a 50-50 unless you gambled it all away at Foxwoods or had 13 girlfriends.
And sometimes it's just a matter of somebody getting even just 5% more, and that may not be a significant amount, but to many judges, that's enough. They got 5% more on equitable distribution, so, they're not going to get alimony or they're going to get very limited alimony.
In that example I showed you, 5% would be $50,000.
Yes.
What difference is $50,000? Well, it's going to help her a little bit. It's going to, it'll be another 2 years before she has to start taking away from her investment.
So as mediators and as practitioners, and I think, as a mediator, I think you can push that envelope much easier than you can as a practitioner, because as a mediator, you're helping them to make that agreement, and if they go into court and say, this is the agreement that we made, most judges aren't going to fuss with that
Well, they won't
unless
fuss-
it
no, they'll never
truly
fuss
is,
it. They'll never fuss
it's
it.
seriously
They-
inequitable.
yeah.
But otherwise, if you're going into court as a practitioner, you can push it, but some judges...
You don't push the envelope, but you make sure that they see all the facts before you end the conversation.
Well, you're helping to raise those issues
Right, just by-
in mediation.
One of the this is a slightly a side issue, but one time I had a person who absolutely would not discuss alimony, and the case clearly needed some alimony because of all the, and so I had my co-mediator work with him. I said, give me 5 minutes. I went in the other room, and I went into the family law software, and I showed the effects of alimony. This is, again, very large disparity in income. And I came back, and I said, I just want to show you, I'm not saying this is the right number, but I just pulled out of the air $3,500 a month for 4 years. And I put it on the spreadsheet here. And this is the effect. This guy was a pretty smart guy and a very, very high-ranking military officer. He looked down and he said, we're done. Because he could see that 50% of that, he didn't have to pay for 50% of that because he's going to get it back in tax savings.
Absolutely.
So it
That's
only cost him
always a draw.
$17.50 a month.
Sure.
You
They
know.
get to deduct it.
Yeah,
Yep.
and so it's not you that make the result happen, it's presenting the numbers that make the result happen. And that's why I know that there are some attorneys who use Kevin, you mentioned Kevin, and other certified divorce financial planners, and they bring them in to the mediation, and they sit as a neutral, trying to help the people see the numbers and understand the numbers. It's a smart thing to do, because they don't have a horse in the race. They're just trying to take. Okay, you've asked me to present you with 4 different scenarios. Boom, 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 boom. Throw it to them, and then they can look at them and talk about them. But if you don't present them with the scenarios, they're not going to talk about it. They're just going to be yes.
I just wanted to bring up one thing about the government people who don't pay Social Security. We settled a legal malpractice case a couple of years ago. A local attorney who, the government worker retired during the marriage and elected survivor benefit. They didn't put it in the court order, and the attorney didn't realize what a diabolical husband this guy was. After the divorce was final, the guy went and revoked the survivor benefit. There was nothing in any of the paperwork that said he couldn't do it. Then he died, and she got zero.
She got a 0.
We sued him, and we got her an annuity basically to give her back the benefit that she would have had. It was a tough case.
Yeah.
But just,
Let me make another point too. This is, again, off subject, but it's about survivor benefits.
because he was already retired and in pay status.
Many government programs, especially military programs, have marital survivor benefits, and you might be the survivor on someone's paycheck as long as they're going forward. But then when you get divorced, you have to put the ex-spouse survivor benefit in. It's a different, you're not married anymore, so that one doesn't count. That's why you have to, the wise thing you do if you're involved in any of this, this pension stuff, is you talk to a pension attorney,
Absolutely.
like Christy Garside in my office, and find out that information before you fill out the property settlement agreement. Because otherwise it's malpractice. And people like you sue. I did want to mention, by the way, I forgot to do it, that my law firm name is now the Law Offices of Howe and Garside, and my partner of 11 years, my young friend of 11 years, is now a partner. And I'm very proud of that. And we have an office. We bought a practice from a lawyer in Lincoln, so we also now have an office in Lincoln. So we mediate in Lincoln now too, and practice law in Lincoln. So,
I want to clarify, so Bruce had a question about provisional incomes. So it's gross taxable income plus 50% of your Social Security plus tax exempt interest, like municipal. And I also want to mention too, if you want to be on my newsletter list and Jeremy's newsletter list, or conversely, if you signed up and you've decided now you don't want to be on, you can sign up on this list, but make it let name it.
thank you.
Thank you.